Society, Pune, and LLM at Pune. Honorable Justice Dr. Gokhale, Madam, completed her doctorate at Bundelkhand University, Jhansi. Honorable Justice Dr. Gokhale, Madam, enrolled herself as an advocate with Bar Council of Maharashtra and Goa in 1992 and started practicing in district and on the High Court, Bombay. Honorable Justice Dr. Gokhale practiced before Honorable Supreme Court in Varanasi. Honorable Justice Madam practiced before Honorable Supreme Court in variety of matters that including constitutional law, adoption law, property law, criminal law, public interest litigations, and matters related to armed forces, etc. Apart from her practice, Honorable Justice Dr. Gokhale Madam was also actively involved in facilitating of distraught women, single mothers, and adoption of children as a part of Mahila Seva Mandal. Honorable Justice Dr. Gokhale Madam is known to voice and represent various matters of public bodies like armed personnel, equal rights of women, guidelines on media trial, etc., to name a few. Despite this, Honorable Justice Dr. Gokhale Madam remained connected to academia and was also a visiting faculty in Law Institute in the last 8 years. Honorable Justice Dr. Gokhale Madam was elected as additional judge of Bombay High Court on 8 January 2020. I request Honorable Gokhale Madam to guide us on topic of comparative study of maintenance under various statutes. Over to you, Madam.
Good evening, Namaskar. I'm very happy. In fact, Advocate Vivekanand Ghadge, Chairman, sir, Dr. Varunchkar, and all other office bearers and officials of the Bar Council, as well as all my friends and my colleague lawyers. Coming to the, at the beginning, I wish to tell you that I'm very, very happy to have this opportunity to interact with you and have this discussion on a very important topic, which I feel it's very important for a discussion. The topic, as we all know, is the maintenance and a comparative study of the concept of maintenance in all provisions relating to personal laws. As we know, the ambit of the concept of maintenance is very large. It is an umbrella which covers anything and everything, right from sufficient support for expenses, for necessaries or essentials for subsistence, to maintaining a standard of living equivalent to that of a spouse. So the concept has gradually evolved by progressive court decisions, and it now includes not only support to the extent of survival, but in some cases, even to live a life of luxury, including, there's a recent judgment, so I'm saying that, I'm referring to that, including to maintaining pets for companionship if the standard of living of the spouse so requires. Coming to the topic, as we know, there are a number of enactments dealing with maintenance provisions. Personal laws contain separate provisions in respect of maintenance. For example, in Hindu personal law, you have the Hindu Marriage Act and the Hindu Adoption and Maintenance Act. For the Parsis, you have the Parsi Marriage and Divorce Act. For the Christians, you have the Indian Divorce Act. And for the Muslims, you have the Protection of Rights of Women on Marriage and Divorce Act. There are various secular and uniform laws also relating to maintenance, in fact, which contain provisions of maintenance, such as the Special Marriage Act. You have the Domestic Violence Act, you have the CRPC, and also now you have the Maintenance and Welfare of Parents and Senior Citizens Act, that is of 2007. Surprisingly, the term maintenance is not defined in the marriage laws of any religion, but the meaning implicit in the term is similar in all these laws. The object basically is to fulfill a social purpose. It is to compel the more affluent, the more capable of the spouse to perform his or her marital, parental obligation, which he owes to the society in respect of his spouse, child, and parents. The less able or the deprived spouse or the child or the parent is not left beggared, destitute, or at the mercy of the society, and thereby driven to the life of vagrancy, immorality, or in some cases, leading to a life of crime for their sustenance. This probably was the reason for the CRPC to contain a summary provision for maintenance. I'm aware that we don't have time to run through all the provisions in detail. But by and large, the criteria and the parameters for determination of the quantum of maintenance is similar in all provisions. Generally speaking, the courts will examine factors such as inability to maintain, proof of a relationship, other factors such as the income or the properties of the other spouse, and so on and so forth. Now, the points of distinction in every enactment are basically directly related to the object of that provision. For example, Section 24 of the Hindu Marriage Act. The object is to tide over the requirement of a spouse to bear the burden of the litigation. So this provision only requires the courts to consider the income of the parties and the requirement of the spouse. But if you place it against Section 25 of the same act, that is the Section 25 of the Hindu Marriage Act, it requires something more. The court can take into account properties of the spouse also, because in addition to the income, because this relates to grant of permanent maintenance. So it thus mandates consideration of properties of the respondent in addition to the income. Now you have the special, you have Section 125 of the CRPC. That's a summary procedure, and hence the degree of satisfaction of the court is much less than the former provisions. Coming to the Parsi Marriage and Divorce Act, maintenance can be given to a wife or a trustee. Similar is the case under the Indian Divorce Act. In fact, there is also a provision of antenuptial and post-nuptial settlement in the Indian Divorce Act. You can refer to Section 40 of that act. In the Muslim law, there is dower, or commonly called meher. That is also akin to a prenuptial. Then the Domestic Violence Act has a completely different perspective. It requires establishing of a shared household, A, B, a relationship in the nature of marriage. So therefore, it is not necessary that the relationship should be always of a husband and a wife, and women in a live-in relationship, insofar as the relationship is in the nature of marriage, are protected. A crucial difference between this provision and other provisions is that only women can be applicants in the provisions of the Domestic Violence Act. In other provisions, except the Special Marriage Act, even a husband is eligible to seek maintenance. But the wording of the Special Marriage Act, if you see, compare it with the Hindu Marriage Act or any other personal law in respect of marriages, the Special Marriage Act provides for maintenance only to the woman's spouse, and not to the husband. Section 4 of the Special Marriages Act provides for marriage between two citizens of India. Section 36 provides for interim maintenance, and 37 provides for permanent alimony. Now, both these provisions, if you pit them against the Hindu Marriage Act or the Parsi Marriage and Divorce Act or the Indian Divorce Act, you can see the distinction is that under the secular law, that is the Special Marriage Act, only a wife can seek maintenance. And here in the other personal laws, both spouses can seek maintenance, and and then it is for the court to determine which spouse is to be given the maintenance. Now we have in the personal laws of Hindus, we have the Hindu Adoption and Maintenance Act. Now Section 18 of that act provides for a Hindu wife to be entitled to be maintained by her husband during her lifetime. She is entitled to make a claim for separate residence without forfeiting her claim for maintenance. Now, the distinction between the Hindu Marriage Act and the Hindu Adoptions and Maintenance Act is that the Hama, as commonly referred to, is available during subsistence of a marriage without any matrimonial proceedings being pending in any court. Whereas in the HMA, that is the Hindu Marriage Act, you can file an application under 24 or 25 once there is a proceeding, any kind of a proceeding, including, say, a divorce proceeding or a restitution of conjugal right proceeding, or even a judicial proceeding. And even after the proceeding is over, in case a decree has been granted, then also the a spouse can make an application under Section 25 of the Hindu Marriage Act. The Hama, on the other hand, provides for maintenance for a widowed daughter-in-law from the father-in-law. It also provides maintenance for children and aged parents, and casts an obligation on a Hindu male to maintain even his unmarried daughter. Whereas now Section 125 of the CRPC entitles only minor children to seek maintenance. Now, what happens to a major son who is taking education but has stopped being minor? There are a lot of cases wherein, say, a wife has got custody of her children, including a son who is, say, in the first year of his degree course. Now, he is past his 18 years majority, and then the husband, under section 24 or 25 or 26 of the Hindu Marriage Act, the other spouse can definitely say that I will not be maintaining the son because he is major. So what does he do? Now, there are a number of decisions of various courts. It's a court-evolved law wherein a number of courts, including the Bombay High Court and the Supreme Court, have actually granted maintenance to, to a major son also if he is dependent. So this law is a law which has been evolved by the courts. Now, Hama therefore has a much larger scope and ambit and a larger umbrella than the Hindu Marriage Act, and even the at times the Section 125 of the CRPC. Now, the Domestic Violence Act has a totally different perspective. That act, the Domestic Violence Act, provides relief to an aggrieved woman who is subjected to domestic violence. Now, earlier, Section 2Q of the Act defined respondent to mean an adult male person who is or has been in a relationship with the aggrieved woman. But now, there was a case in Supreme Court in the matter of Hiral Harsora versus Kusum Harsora. And in this matter, the Supreme Court has held that the respondent now can also be a female in a domestic relationship with the aggrieved person. So a woman can also file a petition under a complaint under the DV Act against a mother-in-law or a sister-in-law or a relative of the husband who is not necessarily a male. Thus, Section 2Q of the Domestic Violence Act was struck down to that extent. For a live-in relationship to be within the ambit of a relationship in the nature of marriage, the Supreme Court has also laid down certain guidelines, such as the duration of a relationship, a shared household, domestic arrangements, pooling of resources, how much money is being contributed in a bank account by each partner, children born out of such relationship, socializing in the public, how are they representing themselves in their social circles, the intention of the parties, etc., etc. Now, of course, a one-night stand cannot be a domestic relationship. That has also been held in the same matter. Now, the concept of shared household has also evolved. In another case, titled Prabha Tyagi versus Kamlesh Devi, the Supreme Court has held that the expression domestic relationship is a comprehensive one. Hence, every woman in a domestic relationship, in whatever manner, has a right to reside in a shared household, whether she has a right, title, or beneficial interest in the same. So now, the right to reside in a shared household is not restricted to actual residence. Having summarily discussed these varied provisions of maintenance in various laws, it is obvious that these very many provisions of maintenance bring with it, and are bound to bring with it, some sort of an ambiguity for say, the family court to decide regarding first, whether to grant maintenance or not, and secondly, if yes, then the quantum of maintenance. I'm sure all of you are aware of the very landmark decision which is in the matter of Rajesh versus Neha, wherein the Supreme Court has described in detail the method of arriving at a fair quantification of maintenance in view of overlapping provisions in various laws. There are many cases wherein a spouse can go and file a petition, can seek maintenance in a divorce proceeding under Section 24 and 25. At the same time, she also files a complaint before the magistrate under the DV Act, or at the same time also seeks maintenance under 125 of CRPC. Now, all these courts do have all these, the jurisdiction is overlapping. So one court cannot say that because you have filed a similar complaint, a similar petition or similar application seeking maintenance is another court, we are not going to grant you maintenance. The court is a jurisdictionally competent court, and the court has to consider as to the quantum of maintenance or the eligibility of maintenance. Now, how is this to be decided is what has been decided, and very important guidelines have been laid down in the Rajesh versus Neha case. Now, some general guidelines have been given in that judgment. The case basically arose from a petition under Section 125 of CRPC filed by a wife for maintenance, seeking maintenance for herself and her minor son against the husband. The family court awarded maintenance, and the husband thereafter preferred an appeal in the Nagpur bench of the Bombay High Court. The High Court dismissed his appeal, against which he filed an SLP. The matter was decided on its own merits, but the Supreme Court found it an appropriate case to once and for all put to rest certain ambiguities on account of this overlapping jurisdiction of maintenance provisions in a number of laws. It is now specified that in subsequent maintenance proceedings, the applicant has to mandatorily disclose the previous proceedings and the order passed therein, so that the next court, the latter court, can take into consideration the maintenance already granted by the previous court in previous litigation and grant or adjust or set off the amount. So if at all, suppose a court comes to a conclusion that that a particular wife or a particular spouse is entitled to say 10,000 rupees maintenance per annum, per month, and the same spouse also approaches the magistrate under 125 or a DV provision, then the magistrate or that particular court, the latter court, will consider the amount granted by the earlier court and then set it off or not refuse to grant maintenance, as the case may be. So but if at all any modification or variation of order is required, then the applicant has to go back to the previous court, which amount or which order she or he seeks to modify. Now, the procedure requires the party claiming maintenance to file a concise application for interim maintenance with limited pleadings, along with an affidavit of disclosure of assets and liabilities as a mandatory requirement. The said affidavit has to be filed simultaneously or within a close proximate time with the other spouse. Because if the wife files, the applicant along with the application files the affidavit of disclosure, and there is a large time gap between the reply of the husband or the other spouse along with his disclosure affidavit, then obviously the other side will have a benefit of having the knowledge of whatever has been written or solemnly or whatever affirmed in the previous affidavit. So therefore, the time gap has to be less. The time for reply has to be only of 4 weeks. Only two adjournments, two opportunities can be granted to the replying spouse to file the affidavit. And if at all the court finds that the delay or the resistance in filing an affidavit by the respondent is willful, or if it is simply to delay the matter, then the court may proceed without the affidavit of the respondent, and at times the court can also strike off the defense of the respondent and proceed to grant maintenance on the basis of the affidavit filed by the applicant spouse. Now, by and large, the guidelines state that only 2 opportunities should be given to the respondent spouse, and thereafter the court has to consider the exercise of power to strike off the defense of the respondent if his conduct is found to be willful or contumacious in delaying the proceedings. So the court then can proceed to decide the maintenance on the basis of an affidavit which is already on record. Now, another point which generally arises is the time gap between the affidavit filed and the hearing of the application. So say, for example, I have filed and made an application today along with my affidavit of disclosure today, and the hearing is going to be held or is held 6 months later. Then there may be a change in my financial status or in any other circumstances which I have not stated in the earlier affidavit. Now, in such cases, the parties are entitled and are allowed to file a supplementary affidavit or an additional affidavit which which can state the change in circumstances in the earlier affidavit. The Supreme Court has also said in those guidelines that in cases where persons belong to the EWS category or below poverty line or casual laborers, it is the authority or the power of the court. The court has the discretion to dispense with the requirement of filing an affidavit. Now, coming to the criteria of determining the quantum, as you all know, there is no straight jacket formula for this. The factor that would weigh with the court will be generally the status of the parties, reasonable needs of the applicant, the educational qualifications of the applicant, independent source of income of the parties, the standard of living accustomed to by both the parties, employment status prior to the marriage and during the marriage, and whether the wife has had to sacrifice her employment opportunities for nurturing the family, child rearing, and reasonable cost of litigation for non-working life. The list is endless. It is totally and entirely at the discretion of the court to seek such details from the parties. It is no answer to a claim of petition that my wife is educated and can support herself. The maintenance amount basically must be reasonable and realistic, and generally to avoid either of the two extremities. Neither should it be too extravagant that the person cannot afford, is not able to pay, nor can it be too meager that the wife or the spouse, the applicant seeking maintenance, is not able to live within that amount. So in a marriage of a long duration, sometimes the number of years spent together can also be taken into account. Then again, there is another difficulty in ascertaining the date from which maintenance can be awarded, whether from the date of application, making the application for maintenance, or from the date of the order. Now, in Hindu Marriage Act or even in the Domestic Violence Act, there is no such provision in the statute itself or in the provision regarding the date on which the court, from which the court can grant maintenance. But if you see section 125 of CRPC, that section actually provides that maintenance should be provided from the date of application. So in the absence of a uniform regime, there is a vast variance in the practices adopted by family courts in the countries. But now the Supreme Court has settled the law and has said that generally maintenance should be awarded from the date of application. I think most of the provisions I have covered under, as far as the laws relating to maintenance is concerned. I think that it will be better if we have now an interactive discussion, and if anybody has got any questions or anything we want to discuss, we should actually open the floor. Over to you, the officials of the Bar Council. If anybody has anything to add or ask any questions, I think let us interact in that discussion now.
Participants, if anybody is having questions, I'm requesting participants, please put your queries in chat box. Honorable Justice, there is one question. If a husband has no source of income, then what to be done? Madam, your voice,
Yes, can you hear me now?
mic is on.
Okay.
Yes,
So
yes, ma'am.
a judgment also, and also it's obvious and logical in the provisions only, that a husband cannot say that I am not able and hence I'm not going to pay. So there's no this ability equal to readiness or willingness to pay. When you have married, and you have got the responsibility of your spouse and your children, you are required to pay maintenance. Now how the spouse gets the maintenance is his, it has to be a responsible thing. But in cases where a spouse is genuinely say handicapped, or suffers from some disability due to which he's not able to earn, then of course the court will consider that, and perhaps the spouse will also have to consider running the family and earning some expense, earning some livelihood for a family. So I see
Thank you,
always.
madam.
Yes.
There is next question is about execution in maintenance proceedings. Do we have to file execution proceedings like that?
Yes. So if at all there is, see, if and say for example, under interim maintenance under Section 24 of Hindu Marriage Act, of or any other interim provision wherein the proceeding is already pending before the court, of course they can make an application to the same court saying asking for striking of the defense. Or if at all the proceeding is over and the maintenance amount has been granted, or even if an interim proceeding is there and you have to and the spouse who's directed to pay maintenance is not paying the maintenance, you can file an execution proceedings, because there is no other remedy in which to under which you can recover the maintenance. Of course you can make application for striking of the defense, that's one. Or second, you can make an application for requesting the court to actually deduct the amount of maintenance from the salary of the husband and credit it directly to the respondent wife. But that's also in the discretion of the court. But the short, the provision which is there is for filing an execution.
Thank you. And one more related execution. If there are changes in the circumstances, can the amount whatever has been granted earlier, we change execution proceedings? Is it possible?
Can you just repeat the question, because your voice was coming a
Yes.
little garbled?
Sorry, madam. Due to changes in circumstances, if there is some change or amount in maintenance, can we change the execution proceeding which has been granted in the order?
Okay, so if there is an amount, X amount granted as maintenance, and there is a change in circumstance of the husband, say for example, if he loses his job, or if his business collapses, or he just doesn't earn as much as he did when the order was passed, then he's also entitled to make an application for varying or modifying the order of maintenance. That's one. Two, if he starts earning more and the wife feels that, oh, his business is doing very well, and that time he did not have a job, now he's got a better job, he's earning more money, or her requirement is more, then she can also make an application for enhancement of maintenance. So if the proceeding is pending, if the proceeding is over, then obviously, see, matrimonial litigation doesn't have a specific cause of action, on a particular date. It's always a continuing cause of action. So at any point of time, you are entitled to make an application for modification of the order.
Thank you, madam. And whether an earning wife is having right to claim maintenance as such?
Of course, like I said, while I was we were discussing the provisions of maintenance, even just because a wife is educated or qualified to earn, does not disentitle her to get maintenance. All the court will see is that if the husband is getting lesser amount than the wife, obviously then the wife will not get maintenance as per her request. But if she's earning a little less than what her husband is earning, then she's entitled to seek maintenance as per the standard of living of the husband. That's number one. And number two, she's also entitled to seek maintenance for the children, if any. Now, if the children are with her and both are earning, then the court will consider directing both the parties to contribute towards the maintenance of the children and proceed to grant orders accordingly.
Thank you, madam. One more question is regarding during pandemic, there was no income, then lenient view can be taken or how it is?
That's actually at the discretion of
Yes,
the
I know.
court. You'll have to bring whatever circumstances of either spouse before the court who is hearing the matter, and it is for the court to actually assess and weigh the inability of either spouse to maintain herself or pay to the other spouse. And I'm sure that, of course, the courts had taken lenient views during the pandemic. Because everybody was in problem. Nobody was, yes.
Thank you, madam. I'm searching for the next one.
I'm sorry?
I'm sorry for the next question, madam. In the case of 498, in order to put an end to murder proceeding by the spouse, the right to settle the matter, how that one-time amount decided.
I think there's some network
Are
issue
you?
here. I'm not able
I'm
to.
sorry, madam. I will ask someone. I'm sorry, madam. I will ask to connect some other person.
Okay.
Ma'am, can you hear me?
No, now I can hear you.
If maintenance application is filed, then can simultaneously DV proceedings for relief of residence can be filed?
Yes, definitely, because the Domestic Violence Act has got provisions for residents also for maintenance, for monetary compensation and other reliefs also. For example, residence orders and property orders. So you can definitely ask for maintenance as well as residence under Section 18, 19,
Okay,
21.
thank you, madam. One very different question. Is there any provision with state fund to grant maintenance in the extreme situation?
For the state, against the state.
Yes, yes.
No, there's no provision against the state. A state, you can't ask for maintenance from the state, not under the provisions of any personal laws.
And can a Muslim lady file maintenance
Yes, definitely.
application?
Of course, under the Domestic Violence Act, under the 125 CRPC, also under their own personal law, that protection of Muslim women rights on marriage and rights on divorce. There are two acts under which they can seek maintenance also. And also, if there is, which I mentioned, there's also a dichotomy or a sort of a dilemma and in conflicting provisions and overlapping provisions between the Senior Citizens Act and the Domestic Violence Act. Because what happens is sometimes a senior citizen, say for example, a mother-in-law and father-in-law are residing, and they don't want their son and the daughter-in-law and his family to reside with them, or there's some acrimony between them. Then they make an application before the Senior Citizens Tribunal, and they get an order of eviction. But at the same time, the daughter-in-law has also gone to the Domestic Violence Court, the Magistrate Court, and sought a relief under the Domestic Violence Act for residence orders. So in that case, what is to be done? So there is actually a judgment of the Supreme Court recently, I'm sure all of you know, Vinita J judgment, wherein the Supreme Court has said that a harmonious construction has to be given to both these provisions, because both these provisions have a non-obstantive clause. That is, both these provisions say, notwithstanding anything contained in any other law, their provisions, they both have an overriding effect. So in such a situation, there has to be a harmonious construction and harmonious interpretation of these two provisions of different acts. So I forgot to mention that actually earlier. So definitely when you said a Muslim woman can definitely ask for maintenance under the 125 CRPC, DV Act, or in case of senior citizens under the Senior Citizens Act.
One more question related to this provision only, whether under 125 of CRPC Christian wife. I want to say, ask rather from any caste can any wife can claim under 125 of CRPC.
Yes, definitely, because 125 CRPC is a secular and a uniform provision. Anybody who fits in the eligibility criteria of Section 125 can ask for maintenance. It includes wives of all religions, minor children, parents who are unable to maintain themselves, and who are neglected, and who are able to show that there is no payment of maintenance by the other spouse.
Thank you, madam. One question is related how the quantum is decided in different law provisions.
Yes, that's what I spoke about. That the quantum of maintenance is directly determined, directly related to the object of that particular act. So, for example, the object of DV is, or the object of 125 CRPC is a very summary provision. So, the degree of proof or degree of depth of inquiry is a little lesser than in other provisions. Or in a Special Marriage Act, there is no maintenance to a wife. Now, deciding a quantum, so many factors which I just discussed will be seen by the courts, and then the quantum will be decided, and also on the basis of those affidavits of disclosure.
Thank you, madam.
Yes, ma'am. On behalf of Bar Council of Maharashtra and Goa, I would like to extend my heartfelt thanks towards our today's chief guest, Honorable Justice Dr. Neela Gokhale, Madam, for enlightening us on today's topic, that is maintenance under various statutes, a comparative study. My lady has enlightened us on a very important topic from the exam point of view. Indeed, it was a very informative session, my lady. I would like to extend my thanks towards a chairman, vice chairman, and the esteemed members of the Bar Council of Maharashtra and Goa. I would like to extend my special thanks towards the Vice Chairman of Bar Council of Maharashtra and Goa, Dr. Uday Varanzikar sir, for organizing this informative lecture series for all the participants. Now, I would like to extend my thanks towards all the participants who have participated in the lecture series. Thank you, each and everyone. Now, I would request the Sharat sir to conclude the lecture. Thank you, my lady. Yes.